Here's what they aren't telling you. A live microphone everyone forgot, a conversation never meant for human ears, and a judge who halted a federal trial without raising his voice, without striking the gavel, without any visible emotion at all. Judge Caldwell didn't shout. He didn't argue. He went completely, chillingly silent. Then he did something that froze an entire courtroom in place. He ordered U.S. Marshals to seize the defense team's laptop in front of the jury, in front of the cameras, in front of the very attorneys who suddenly looked like they were watching their careers evaporate in real time. What was on that laptop? What was in that recording? And why has everyone involved stopped talking? I've replayed the footage over and over, and every time a new detail stands out. So what pushed Judge Caldwell to that edge? What single moment made him stop a multi-million-dollar fraud trial in its tracks? It started with a microphone that never shut off. During a routine recess, that mic picked up a conversation between the lead defense attorney and someone who absolutely should not have been speaking with him. And this wasn't random. This was weeks of strange behavior finally catching up to them all at once. To understand why Caldwell reacted the way he did, you have to understand what the defense believed they were getting away with. The case was already volatile, high-profile fraud, millions at stake, influential names hovering in the background, the kind of case that makes reputations or destroys them. Judge Caldwell had presided over 3 months of motions, objections, and a defense team that seemed just a little too prepared, a little too confident. They anticipated prosecution moves before they happened. They handled witnesses with almost supernatural precision. People noticed nobody could prove anything until that microphone stayed on. Tuesday morning, 10:47 a.m., Courtroom 4B. Caldwell called a standard 15-minute recess. The jury exited. The prosecution organized their notes. The defense team gathered in the corner, speaking in low voices, assuming privacy. They were wrong. The courtroom's audio system, installed for accessibility and record-keeping, has microphones throughout the room. During recess, it's supposed to go dormant. Supposed to. Whether it was a glitch or something else, the defense table microphone stayed live. It captured everything. The lead defense attorney whispered, "She changed her story. We have the new version. They don't know she talked to us." Another voice responded, not a lawyer, not a member of the legal team. "She's nervous. She'll say what we told her. Just make sure the judge doesn't find out about the contact." The exchange went on. References to altered testimony, mentions of the arrangement, and then the line that reportedly made Judge Caldwell's blood run cold. "Caldwell won't know until it's too late." The audio was being monitored in the clerk's office. Within a minute, the recording was in Caldwell's chambers. He listened once, then he walked back into the courtroom. Witnesses say his face was completely neutral. No anger, no shock, just calm. He looked directly at the defense table. "Mr. Harrison," he said flatly, "remain seated." Harrison tried to stand, tried to object. I said, "Remain seated." That's when the marshals moved, not toward the attorney, but toward the open laptop on the table. "Your Honor, this is outrageous." "What's outrageous," Caldwell interrupted, "is what I just heard on the courtroom audio feed. That laptop is being seized as evidence. Surrender all electronic devices. Now." The jury was rushed out. The prosecution sat stunned. The defense team watched as laptops, phones, drives, everything was bagged and tagged. But Caldwell wasn't finished. "This trial is suspended pending investigation. All defense counsel are barred from contacting the defendant, the witnesses, or each other." Harrison's face went pale. "Your Honor, our client has rights. Your client's rights are not the issue. Your conduct is." Then Caldwell said the line that rippled through the entire courthouse. "You are not under arrest yet, but obstruction of justice, witness tampering, and conspiracy are being evaluated as we speak." Silence. Total silence. A sitting federal judge had just acted with the speed of a prosecutor after hearing what sounded like real-time coordination of testimony. But not everyone agrees with what he did. Defense advocacy groups immediately called it dangerous overreach. Civil liberties attorneys questioned the legality of the recording, the seizure, the potential violation of attorney-client privilege. Was the audio even admissible? Did Caldwell have authority to seize devices without a warrant? What if the conversation was taken out of context? Legal experts are divided straight down the middle, and that's where this gets complicated. Weeks earlier, a key witness, Maria Delgado, had abruptly changed her testimony. Her original deposition was devastating to the defense. Then, 3 weeks before trial, her certainty vanished. Documents she'd authenticated were suddenly unclear. Numbers were misremembered. The prosecution raised concerns. They couldn't prove anything. Caldwell acknowledged the unease but had no grounds to act until he no longer had to rely on instinct. That microphone gave him evidence. When the marshals seized the devices, most people thought it was a spontaneous reaction. It wasn't. During that recess, Caldwell had already called the U.S. Attorney's Office. By the time the devices were bagged, federal investigators were en route. The audio had been preserved with chain of custody. Caldwell had prepared the legal justification under the crime fraud exception to privilege. He hadn't panicked. He had executed. Some legal analysts now say Caldwell may have been completely within his authority if what he heard truly constituted evidence of ongoing criminal conduct. Others warned that if he's wrong, he may have irreparably damaged a defendant's right to counsel, and then the defense made it worse. Instead of staying quiet, Harrison held a press conference on the courthouse steps, accusing Caldwell of judicial tyranny and vowing to take the fight to the Supreme Court. Within 24 hours, protesters gathered. Online harassment escalated. Caldwell's home address was posted. Threats began appearing. U.S. Marshals placed him under protection. His family was moved. All while the investigation intensified, the FBI's Public Corruption Unit reportedly took lead. That's unusual for simple witness tampering. It suggests something larger, something involving more than a defense strategy. The defendant in the case has ties to powerful people, political donors, influential names no one wants appearing in federal filings. Now consider the strangest detail, the unidentified voice on the recording. It wasn't a witness. It wasn't part of the legal team. Sources say voice analysis suggests someone connected to federal law enforcement, which raises a chilling possibility. Was this a mistake caught on a hot mic? Or was this a trap that had been set long before the recess ever happened? The trial remains suspended. The defendant is in custody. The defense attorneys have been suspended from practice. Their firm has effectively vanished. The devices are in FBI custody, undergoing forensic analysis. Judge Caldwell has filed to have the full audio sealed, citing sensitivity to ongoing national investigations. National, not local, not state, national. And only fragments of that 6-minute recording have been publicly referenced. What's on the rest? Right now, Caldwell is under 24-hour protection. His courtroom operates like a fortress, and he hasn't said a single word publicly since that day, which might be the most telling detail of all, because this may not be a simple story of a judge catching corruption. It may be something far more complicated, a trap within a trap. And whatever happens next is going to be bigger than anyone in that courtroom expected.